Guys ready?
Yes.
Let's go on the record on cause number DC 242582. Janice Fagan versus City of Dallas. Council, make your appearances.
Jesse Schulter for the plaintiff, Your Honor.
William Sanders for the City of Dallas.
All right, let's proceed.
Your Honor, this is the city's plea to the jurisdiction, so I'll proceed. As the court knows, this accident stems from a trip and fall accident, which occurred on 5/50/27 Live Street, Dallas, Texas, on a sidewalk adjacent to an apartment complex. This accident happened on February 27th of 2023. On the day in question, during the daytime, Ms. Fagan was navigating down the sidewalk when she tripped and fell over a small piece of protruding rebar on the sidewalk. The piece of rebar in question was between 1.5 to 2 inches in height. As a result, plaintiffs sued the City of Dallas along with DART and 2 other co-defendants. As it relates to the City of Dallas, the plaintiff brought claims of premises liability and negligent use of personal property. As it relates to the premises liability claim, the plaintiffs alleged that the hazardous condition in question constituted a special defect, which imposes a higher legal standard upon the city. And so the city filed its plea to the jurisdiction on the basis that this small protruding piece of rebar does not constitute a special defect, and that the city did not have actual knowledge of this allegedly dangerous condition in question. If the court should be so inclined to in fact find that the condition in question was a special defect, the city is also proffered to the court that the city had no constructive knowledge of an allegedly dangerous condition. The plaintiff has also filed a motion for continuance, which we will address following the plea to the jurisdiction itself. And so going back,
Why wouldn't we do the continuance now?
If the court would like to address that now, I don't mind
Okay,
addressing that at this moment.
all right. Why do you need a continuance on this?
Yes, Your Honor. So we've been trying since November 25th to obtain the deposition of a corporate representative for the City of Dallas. Back in December, we had filed a motion to compel that deposition because there was some conflicts between what topics were more appropriate for that corporate rep. We initially had that set late January, but due to a court conflict and the trial was still going on, we pushed it to late February. So the court granted, in part, our motion to compel, ordered the City of Dallas to identify and produce a corporate representative on the topics that were permitted. On April 1st, I reached out to the City of Dallas requesting deposition dates again. I received no response. I followed up on April 9th and again received no response. On April 10th, the City of Dallas unilaterally set the plea to the jurisdiction for hearing for April 21st.
I'm trying to figure out what you would really need in this case when it comes to discovery. Like, why would you need discovery to respond to this?
Well, because without actually speaking to a corporate representative to see, there's questions about permitting process. I assume that if DART's going to be doing some sort of excavation on city sidewalks, there's going to be
I would agree on a summary judgment. Obviously, we would allow you to do discovery. Plea to the jurisdiction. I'm just not what type of jurisdictional discovery would you need in this particular case? It seems like the facts are fairly clear, and we go based on the pleading anyway, right?
Yeah, if it's based on the pleadings, then sure. But the way they've sort of argued their plea to the jurisdiction, they're trying to get out on it. The kind of case that there's no evidence motion for summary judgment, saying that there's no actual evidence of actual constructive knowledge, which is sort of why we're saying that we need the deposition. If it's based solely on the pleadings, which I think it should be. We've asserted alleged facts that they knew or should have known that this condition existed, which I think would open up the jurisdiction to the court under the TTCA.
Response.
Yes, Your Honor. Firstly, and not that this applies to a plea to the jurisdiction, but a sufficient time for discovery has passed for plaintiff's counsel to produce some evidence that the city had either actual.
When does discovery close in this case?
Well, we had an initial scheduling order and then there was a continuance granted in February to push this case to October 14th. I think that's the exact.
Did that extend the discovery deadline or not?
I
I
believe
think
it
it
is.
is, yeah, I don't want to make a misrepresentation to the board one way or the other, but. The reason was at that time, it was granted at the time we were filing the motion to compel, they were filed concurrently.
I mean, in the original scheduling order, did that have a discovery deadline? Usually they do.
I would imagine that it did, but again,
And when you extended it, you don't know if it extended the discovery deadline or not.
Again, I believe that we extended the discovery deadline.
I think for the purposes of these depositions, right, that was sort of the.
I mean, okay. I mean, it's kind of important, right? I mean, if the discovery deadline hasn't passed.
If I may continue, Judge.
Well, I mean, we need to resolve that issue first, don't we?
Well, I believe that we're both representing that it did, I just.
That it did extend it or did not extend it?
I believe it extended it, but to be honest with the court, Your Honor, I'm not 100% sure that we did, and so. To the jury's point, so the word's point is maybe an issue that we need to resolve before we continue forward.
You want me to look it up or do you want to look it up or do you have the? Okay. Here, I'll try to look it up.
Yeah, sure, I didn't see the schedule. And there wasn't necessarily an order on the continuance that was granted orally at the motion to compel hearing, if I recall correctly.
And then there's a deposition set on this, I guess.
July 16th, Your Honor.
Great. Hey, Rhonda, are you having problems getting on Odyssey?
No, mine seems to be working. Did you want me to look up something for you real quick?
No, I mean, yeah, if you want to see, is there a scheduling order on this case?
Let's see.
Figured it out. Let's see.
I'm looking, um,
So to the interns, kind of why this is important is if discovery has expired, then there's really not an argument to be made that there should be additional time for discovery. So that's kind of why we're looking this up.
and just to clarify, this is for the Fagan versus City of Dallas case.
Yeah,
I don't see a scheduling order on her, sir.
was there ever a scheduling order on this? I don't see one.
I don't believe so. I didn't see one either. I checked the docket and the summary part.
Was this a level 3 case? And you guys have a scheduling conference maybe with me?
It was level 2.
That's unusual. Okay.
We have it logged as a level 2.
You have a trial setting on this one? When's the trial setting?
Should be October 14th.
October 14th. Okay. All right. Well, it doesn't appear, well, discovery is still open until 30 days before trial. So you may proceed. So what, I guess that goes back to the question, then what discovery why do you feel like you need discovery to respond to this plea to the jurisdiction?
Sure. The majority of their arguments based on this knowledge requirement that needs to be provided as evidence, whereas I think case law is clear that this plea to the jurisdiction is determined on pleadings. And in the pleadings, we've asserted that.
That's not all they're arguing, though. They're also saying that the rebar isn't large enough to constitute a special defect, right?
Correct.
And I mean, you don't need discovery for that.
No, I think we can have that argument here today, Judge.
Okay. All right, well, let's proceed on what we can.
As it relates to the issue of special defect, Your Honor, as the court is well aware, the concept of a special defect is intended to address rather large and substantial anomalies and disruptions.
You cited a number of cases in the briefing where they did find a special defect. Are there cases out there? And you distinguish the cases saying, well, in this case, it was 9 inches instead of 1.5 inches and blah, 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 blah. Are there cases that have said that this defect is too small and therefore would not be a special defect?
As far as,
Do you understand what I'm saying?
as far as cases specifically stating that the defect was too small and therefore.
Because that seems to be your argument, is the defect was too small, right?
Well, essentially, Your Honor, that the defect.
Or not serious enough, maybe.
Essentially.
So what cases are there out there that have said this defect was so minor that it doesn't constitute a special defect, or however you want to word it?
Sure, yes, Your Honor. City of, Monroy, excuse me, versus the city of Dallas.
Can you say that again?
Monroy,
How do you spell that?
Monroy.
Do you have a copy of that case?
I do, Your Honor.
Yeah, why don't you read it?
It's a bit highlighted.
That's fine.
With the.
And do you guys have a hearing binder for me? With cases and everything?
I can get you one on the notice that says the first comments. It's just,
Oh, really?
yeah.
We have a paralegal call and see if the court needed anything.
Yeah, I usually will ask Ron if I need it. I'm gonna probably want one for this one.
Okay.
Got a question when you're ready.
About what?
Well, he's wanting to get this, in particular inmate served in federal, prison, right?
In Atlanta.
In Atlanta. So are you requesting me to talk to the federal, agency over there?
Think so, sure.
And also the sheriff's department, because I would have to talk to both of them.
Whoever you need to talk to get this to occur. So that's why I wanted him to come in, was to talk to you, so you could talk to whatever we need to do to
Okay.
get to where we need to be.
This is
But
what
we got guys, but I'm in the middle of another hearing, so let me do that first. All right,
So, Your Honor, in McRoy, a
Mon-
similar
Monroy,
Monroy, excuse me.
I just want to make sure it's not a different case.
In Monroy. This involves a similar situation as we're here for today, where a pedestrian was walking along the sidewalk. However, in Monroy, a portion of the sidewalk was elevated, creating a lip, which the plaintiff tripped over. The court in that case held that small disruptions in sidewalk conditions don't reach the level of an excavation or an obstruction sufficient to invoke the heightened legal standards and protections that accompany the term special defects. A similar situation or a similar holding. Excuse me, Your Honor. In Hinman versus State Departments versus. In Hinman versus State Department Highways and Public Transportation. The court in that case held that a small bump along the shoulder of the freeway similarly didn't constitute a special defect.
It was a slightly uneven roadway is not necessarily a danger, is what they said, if I recall. So
Correct. And the court noted that because the pedestrian in that case had the ability to go to the left or the right of the small bump that was on the shoulder, it couldn't be considered an obstruction, nor could it be considered.
Isn't this kind of different? This is a piece of rebar that's sticking out. I mean, I guess you're just saying because the rebar was so small, it shouldn't have constituted a special defect. Is that it? Because
Correct, Your Honor.
they clearly did not intend to have the rebar sticking out, or maybe they did. That doesn't make a lot of sense to me if they did.
Sure, I can't imagine that the rebar was intended to be sticking out.
How long was it out?
That we don't know, Your Honor. We know that DART removed the bus station back in 2022. However, we don't know what the condition of that rebar was from 2022 through the time of Ms. Fagan's fall.
And this was in City of Dallas property, correct?
On the City of Dallas sidewalk, yes. However.
You believe that DART caused this to happen when they tore out you said a bus station or train station?
Yes, it was a bus, formerly a bus stop,
They tore it out.
yes.
Do you think that's what caused the rebar?
We believe that's what caused the rebar, however, there hasn't been confirmation.
There hasn't been enough discovery to know the answer to that.
That's been the assumption, Your Honor. And I'm not sure that.
If I can clarify, Judge,
Yeah,
there's photos, I don't know that it's necessarily been produced here, but the rebar in question was used to bolt down one of the pillars, the 4 pillars of the bus stop. When it was removed, almost every other rebar piece sticking out was ground down, but this one, and there's one other one related to the trashing that was left behind. There's Google map photos if you look at opposing counsel, one of the parties that's out of the case, and had provided kind of a before and after based on that Google photo, where you can see where that particular bolt was, because there was another set of 4 bolts in the previous bus stop that had been ground down, to sort of gives you the timeline. So
but based on the Google photos, how long was this?
they tore it down about, I think, 10 to 12 months prior to the accident.
Okay. Did you have anything else?
Yes, Your Honor. To finish on the issue of whether this constitutes special defect, going to the brief, going to our original brief, which included the required case law, and our response brief, which included additional case law, I think it's clear that this minor, small piece of rebar could have possibly constituted an excavation or an obstruction as contemplated under the Texas Tort Claims Act. And that gets us to the issue of actual notice, and in support of our contention that we didn't have actual notice, we produced the affidavit of Lawrence Laurent, who's a manager with our 311 department, who indicated that in the 3 years prior to Ms. Fagan's call, the city didn't receive any reports or any phone calls related to this allegedly dangerous condition. And the Texas Supreme Court and University of Texas Pan Am versus Aguilar has indicated that once a governmental entity produces reports of this sort, indicating that they have not received any complaints or any calls related to a potentially dangerous hazard, the onus then shifts to the plaintiff to prove some evidence of actual knowledge. And it's our contention that plaintiffs have not met their burden to do this, so can't meet their burden to do this here today.
So that really goes to the issue of knowledge that we probably need discovery on, right?
I don't believe we need additional discovery on that, Your Honor, because it's our position that necessary discovery has already been conducted. Written discovery has been circulated. And again, going back to that affidavit of Mr. Laurent, the city has demonstrated that it did not have actual knowledge.
Okay, response?
Yeah, Judge, with respect to the affidavit, first time that was produced was April 10th, when they started to set this for hearing and then filed a brief. So that's the first time that we were aware of this particular witness. I don't believe he's identified as a person with knowledge about facts. They sort of just sprung this on us and said, here we are, you have no actual knowledge to rebut this until we prevail. And so I think that goes again to our
I
request.
mean, this case was filed back in February 2024. I mean, this has been going on for quite some time.
Yes, Your Honor, and if you look at our reply brief, back in August 25, I had emailed all parties at that time that were in the case and said, we're at a point in the stage, we're either gonna start taking a bunch of depositions, or should we try to mediate this thing early? If you look through it, Dart and Dallas never respond. To the point where opposing counsel, for one of the related neighboring entities had said, I don't think they're gonna respond. At which point then we added another party who had actually installed the bus stop toll manufacturing, which sort of puts a halt on wanting to take deposition when you're adding in a party to get them involved. They soon settled out in November, which is why then we started pushing for these depositions to the corporate reps. They've already sort of laid out the timeline as to why it's taken so long for us to get there. But with respect to the special defects, they've sort of defined the special defect as a condition that it only needs to be in the same class as an excavation or obstruction to constitute a special defect. And this particular special defect was only there because of the excavation of tearing out that bus stop. There is case law that identifies certain conditions on a sidewalk that would be considered a special defect. In the city of Austin versus Brand Health, they determined that an uncovered water meter box in the sidewalk was found to be a special defect. There was a hole on the city sidewalk where utility pole used to be. That was in the city of El Paso versus Chacon. And then in Stokes versus the city of San Antonio, an uncovered storm sewer drain alongside of the road where a pedestrian would normally walk was considered a special defect. There is a test to determine whether or not something in particular is a special defect that's been set forth, and it's the size of the condition, whether the condition unexpectedly and physically impairs an ordinary user's ability to travel, whether the condition presents some unusual quality apart from the ordinary course of events, and whether the condition presents an unexpected and unusual danger. And I think the reason the courts have held sort of that shifting sidewalks aren't necessarily special defects is because we encounter them every day. It's sort of expected when you're walking on sidewalks. They're going to shift, they're going to be a little uneven. So that's not unordinary for you to encounter something like that. But for a 2-inch piece of rebar sticking out of the middle of the sidewalk, I don't think many people would expect to encounter that in my client. Certainly didn't expect to encounter it when you walk across it.
Okay,
If I may respond.
sure.
It's worth noting that the unusual and unexpected nature of the hazard is considered in the context of the overall condition of the scene on which the accident happens. In this case, as our photos depict, the sidewalk itself was of low quality. And so Naturally, Ms. Fagan should have been on notice to be careful in the area in which she was. The overall condition of that sidewalk as it relates to the rebar itself was much worse than the hazard presented by the 2-inch rebar protruding. And again, the photos of the sidewalk that we presented in our brief effectively demonstrate that. To council's point, the size does matter and the impairment of plaintiff's ability to travel does matter as well. And in this case, Ms. Fagan's ability to travel was not impeded. As courts have ruled in other cases, Ms. Fagan had ample opportunity to go to the left or to the right of the protruding rebar. And the size of the rebar was of such small nature and stature that it couldn't possibly constitute a special defect under the Texas Tort Claims Act.
Okay. Well, this is what I'm gonna do. Go ahead and put together a brief book for me that has all the briefing in it, you know, the plea, the most recent amended petition, the responses, the replies, as well as cases. Who wants to do that, and when can you get that done?
Our office can do that, Your Honor. Would
Just work together on it.
Yeah, we can get our cases put together, highlighted and sent over to Mr. Sanders to incorporate into that. Book.
I think we can add that to the court by next Friday.
Hmm,
Is that too long?
how about next Monday?
Sure.
Give it to me next Monday. You have an able young law clerk here that can help you.
I've already assigned it to her, Judge.
Okay, good, good. She's a former intern. That's, I don't just pick on random people. Was it last summer or some summer? All right, guys, anything else today?
Nothing from the defense.
No, Your Honor.
All right. You guys have a great rest of your day. Very good briefing on both sides, and just try to get me that notebook by the day.
Thank you, Your Honor.
Thanks, Judge.
All right, thank you. And here you can have this case back so that you can put it together in the notebook.
All right, Judge, I talked to the sheriff's department over there, and the sheriff's department is actually calling one of the deputies out in the field to have that served. They're saying within a day or two they should be taken care of.
All right. Rhonda, are you there?
Just a minute. Yes, I'm here, Judge.
Okay, so we have this case that's had multiple resets on the VWAP docket. It's this Thorne versus you case. Do you see it?
Thorne versus you, please.
You.
Thorne
Oh,
versus. It's on our status conference.
uh-huh.
So that's set for the dismissal docket on Monday. Go ahead and reset that another 30 days.
Okay.
So Mr. Clark got that taken care of for you, so make sure that you follow through.
I'll do it now.
All right, thank
They're
you.
gonna make their first appearance and, you know, dealing with the feds. The sheriff's office there is dealing with the feds and they're doing it in their sweet time.
Well, hopefully this will help. So
It will.
we'll see you in 30 days.
Thank you, Judge.
Do I get extra pay now?
I'm gonna give you a gold star, Gary. I'm gonna give you a gold
Yeah.
star.
In my first year as a lawyer, I brought all the court coordinators a small little deal of whiskey.
Oh, did you?
I didn't know.
You're not supposed to do that. Do not bring a small thing of whiskey to the court coordinator, so. Mr. Clark, good to see you. So we have one more hearing. The trial docket kind of cratered, or the hearing docket kind of cratered today. We had about 7 or 8 hearings set. We're down to 3. That first one I thought was very interesting. This one, Mr. Clark, was pretty simple. So we have one left that involves a motion for new trial. It's a very interesting. Did you guys study adverse possession?
Yes.
So it's very rare to have an adverse possession case actually go to trial. I could probably count on one hand of how many times that's happened. But it was an interesting one where the mom buys a house and she works for like AT&T. She worked there her whole life. She decides that she wants to move to a new house and she lets her son move into the house. And because the house is paid off, and the agreement was that he would pay the taxes and she would pay the insurance on the house. And then he lived there a number of years. He gets this new girlfriend or wife, I think, eventually. And I think the wife convinces him that, I don't know, she reads on the internet about adoption, that they were adversely possessing against their mother, even though she gave them permission to, even though she gave them permission to live there and was paying for the insurance. And so the son and his wife lost the trial, and now they're moving for a new trial because there's an issue involving upgrades. So yeah, son of the year, not this kid.
Okay. What was the level 2 and level 3?
Oh, guys, this is something that very good question that he has. Were you gonna leave, Yvette? He asked a really good question, guys, that I think this will be good for intern Jeopardy. So in every civil lawsuit in Texas, you have 3 discovery plans that are potentially in place. There's what's called the level 1. We call it an expedited trial plan. It is theoretically for smaller cases. And it is, actually, let me do this here. Remind me to talk about discovery plans once we get there. I think both sides are here. Hey, Fred, how you doing? All right. Are both sides here?
We're here, Your Honor. We're just our attorney is actually headed downtown. So
I need a completely new wardrobe. Everything's too big for me now.